Yeah, but you got a reputation.
I'm here.
So I would not be late.
Okay.
Jeez.
Speak into your mic.
You all ready?
Yeah,
Okay.
I'm getting old.
The Board of Zoning Adjustment, City of Osage Beach is now in session. Please stand for the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Go Navy.
Will the clerk please call the roll?
Commissioner Green?
Here.
Commissioner Catcott?
Yes.
Commissioner Gross?
Here.
Commissioner O'Keefe?
Yes.
Commissioner Bauman?
Here.
Are there any corrections to the minutes of our January 15th, 2025 meeting? If not, the meeting minutes stand for approval.
Make a motion.
Second.
All in favor?
Aye.
The Board of Adjustment is a committee created by Missouri State Legislature and governed by the revised statutes of Missouri, 1986. It is a committee for the City of Osage Beach and functions under the Circuit Court of Camden County. Composition of the board is prescribed by RSMO 1986, Section 89.080, as having 5 full-time members and 3 alternates. A variance requires an 80% vote of approval to pass. This means 4 affirmative votes. Therefore, 4 members must be present to convene a meeting. If only 4 members are present, we do allow the petitioner to delay their hearing until 5 members are present if the applicant wishes. In order to grant a variance, the board must find that special circumstances exist which are peculiar to the applicant's land, structures, or buildings that do not generally apply to the neighboring structures in the same area and cannot be reasonably addressed within the existing ordinance. Also, if strict application of the provisions of the city ordinance would deprive the applicant of reasonable use of the land, structure, or building in a manner equivalent to the use permitted other owners in the same district, then a variance could be granted. The board must ensure that the special circumstances is not the result of action of the applicant taken subsequent to the adoption of the ordinance on May 10th, 1984. It is incumbent on this board to help ensure public safety by not granting a variance that would obstruct the functioning of the fire, police, and ambulance services in the performance of their duties. It is not the intent or purpose of this board to eviscerate the Planning and Zoning Commission or perpetuate ongoing nonconformity with city ordinances. Appeals of the board's decisions must be made to the Camden County Court, not to the City of Osage Beach. In a few minutes, all interested parties will be allowed to address the board. We ask that you step forward to the microphone and state your name. You will take an oath to speak the truth in this manner. We now call case 354. The applicant is Peter and Mary Ignell. Have all the legal notice requirements been met for the hearing?
Yes, Mr. Chairman, they have.
Has the city made a prudent effort to notify by mail adjacent and otherwise obviously affected property owners?
Yes, Mr. Chairman, we did.
Were there any written responses?
I did receive a response, a letter from the Property Owners Association from Harbor Heights in recommendation to deny this request, and it has been placed in the case file.
Okay. Would the city planner please describe the variance requested and the conflict with the ordinance?
Yes, Mr. Chairman. First, I'd like to enter in for the record as Exhibit 1, the Osage Beach Municipal Code, and as Exhibit Number 2, Variance Case File 354. So basically what we have here today is the request by Peter and Mary Ignell to build a detached garage in the front portion of their property. The issue that they have as it pertains to why they need a variance is that the request falls within 0.89 feet of the front property line, which is the roadside, and 4.3 feet from the side property line. As you know, the required front setback in an R1 zone is 25 feet from the front property line, which would be the roadside, and 10 feet on the side. This request comes to you because obviously at 0.89 feet and 4.3 feet, they don't meet those setback requirements. With that being said, It's not often that we see a request as what we're seeing today. I can tell you that from the perspective of the front yard setback specifically, there's a reason for setback requirements, which are, one, safety, two, it's a line of sight requirement for ingress and egress, and three is aesthetic, okay? What I will tell you is, and I brought the city administrator, who is now acting as Public Works administrator currently, and of course Cole is here, just to discuss some concerns that we have with the particular request. The main of those being, you know, with its close proximity to the road, and you're talking about less than 8 feet from the edge of the hard surface, it's a situation to where our public works will have issues with their normal services, whether it be when they're plowing the road, when they're running the street sweeper, if they're mowing or weed eating the right-of-ways. It is always going to place this particular structure that they're requesting kind of in a spot where it could have the condition to be damaged by something that we're doing. That doesn't include something that we may do as far as needing to resolve or work on any kind of infrastructure that is in the right-of-way in that area. The water line actually runs in the street out in front, so it would probably be okay, but the bigger issue that we have come across with the request is that there is a sewer line that runs from our main on the opposite side of Greenwood Circle down the side of this property to the grinder station that is next to the existing home. And it appears that the location that it is, along with the valve, is in a position that is at minimum within our required easement around our sewer line, if not on or over the top of the existing line. And with that being the case, it's not even something that we can grant a variance for. So I wanted to get that out right up front so that you will know that. Devin, do you have anything that you would like to say?
Wow. Well, like Carrie talked about, you know, future road construction, accessing the infrastructure in that area also poses a concern for the type of commercial vehicles that our Public Works Department operates. So that's a concern as well. They're not used to having structures so close to the road when they're trying to operate dump trucks and things like that. So that's all I have to add.
One other thing too that I wanted to bring up is if you see the location of the house to the north and then the driveway that goes into that property, the proposed location of the requested garage would at minimum cause some line of sight issues, whether it be from people on the road or coming out of that driveway. That could be a safety issue as well, so it is a concern. With that, I will give it back to you for any questions you may have of us.
So any of the board members have any questions for Carrie?
For you?
Well, you can
Well-
ask me, or you can go ahead and have people come up and speak if you would prefer that, and then you can talk to us.
Yeah, I'd
later.
like to let them speak and
Okay.
then come back to them.
Okay. Does the applicant desire to amend, add to, or clarify the reasons for this request?
Do you want to see her, Gary? Maybe. Do you need me to sign in? Yes. Just a second, Chairman. Mr. Chairman, my name is Derek Smith. I'm an attorney representing the Ignills on this.
We need to have you sworn in.
Oh, okay.
Okay.
I do.
Thank you.
Thank you. Like I said, my name is Derek Smith. I'm an attorney. I represent the Ignills on this. I did want to talk. I don't know if we need to amend the application, but I would like to discuss a little bit about the information that Carrie discussed and about the distances from the right-of-way. It's our understanding that the actual road as built doesn't go up all the way through the right-of-way. If you would agree with that? There's a gap between the concrete pavement
Yeah, it would be, the existing build, or the proposed building would be approximately 7 feet from the edge of the hard surface.
Right, so putting up the structure of where it's proposed to be would not be right on, or right next to the hard surface. It's approximately 7 feet away, so our contention would be that would be far enough away for safety of the trucks and everything going on use of the roadway. Did you have any other particular questions? We set out the reasons why we're requesting the variance in our packet. That's pretty straightforward, I thought, in our opinion. I can expound on that if you would like.
I've got a question for you. The existing wall that has the bolts sticking up out of it, how old is that wall?
And I'm going to probably have to turn you over to Mr. Ignell to answer those specific questions.
Testimony you're about to give is the truth and nothing but the truth?
Yes. The wall that's
I
existing.
can't hear you.
Oh, the wall that's existing was when the house was built, 88, 89, 90, 91. All the driveway, all that was existing, and what it has the bolts set up, it just appears it was set up for a garage back then. I have no clue. That's whatever, 20, 25, I guess you could say close to 30 years ago. So with that, we've raised the driveway 3-4 feet. So the wall, the retaining wall was there, was probably 5 or 6 feet lower. So we raised it so we have less of a slope to pull into the driveway where hopefully the future garage would go. So if anyone was driving there, they would have fallen off a 6 or 7 foot ledge the past, I guess you can say 30 plus years from the 90s. So it's always been there, and the pins have always been there.
So you're going to use that existing wall as part of the structure if it's permitted?
Correct.
Were you given the bylaws when you moved in from the association?
No, we were not.
Okay. Thank you.
Are you aware of those bylaws?
I am not aware of them.
I will say that this is just the first step. We have to get approval of a variance before we proceed further. Of course, we'd have to abide by any sort of restrictions that are on the property moving forward.
Well, when I read what the Harbor Heights Property Owners Association provided, they are stating that no building or structure shall be commenced upon any lot until the location and the complete plans and specifications have been submitted and the same approved by the board. Now, did you make any attempt to do that?
Mr. Chairman, I mean, at this point, we need to get approval of a variance before any plans can be submitted to any association. I need more information about when those bylaws went into effect, who they actually affect, if they were placed on this property. I'm not sure that they have been.
Yeah. I really disagree, number 4 and number 5. I mean,
You'll have to forgive me, ma'am. I'm not sure which ones those are.
it's in regards to the value.
Yeah.
I don't see that being an issue. And the character of the neighborhood. I mean, I live not in that neighborhood, but close, and I go through there all the time. There are plenty of steep hills. So I just don't agree with 4 and 5.
And I do apologize, ma'am. I'm not sure what you're referring to.
It says it's to
Are you talking about the letter?
the letter
from
Harbor
the
Heights.
letter from the property.
I've not been provided a letter from the property
Oh.
association.
Well, it basically says that they don't think that it was going to improve the value of said property, and that the location is opposed to the character of the rest of the neighborhood.
And I would agree. I don't think a garage is going to
No.
devalue the property. I think it would increase the
You can hardly
value.
see it.
And there are other garages in the area.
True.
This lot is a narrow fronted lot, and it goes steeply down to the lakefront. There's not another place to put this based on where the structure is presently located, which is where it was when my client purchased the property.
Can I ask a question? Mr. Engel, did you go through a title company when you closed on your house?
He did.
Typically, those bylaws are with those closing paperwork. That, if it's an HOA, I would imagine they have them, because I don't know very many HOAs that don't, because you really do have to follow those.
I can say that Mr. Ignell was provided with a title policy that set forth that there were restrictions set forth on the plat of Harbor Heights. Those documents do not set forth the right of this association to set forth these requirements, in my understanding.
I guess my question would be to the HOA, do you have those documents? But that wouldn't be something you could answer. I mean, the HOA is going to have to answer that.
And I agree, I have not reviewed the bylaws of what they purport to be
I
Harbor
can just tell
Heights.
you, having dealt with HOAs and POAs for 38 years, you get those at closing, and I know a lot of people don't realize, and they just file everything away in their safety deposit box, and they don't know that you have to get, there's concern from your HOA that, I guess, whatever else building you did prior to this request, you didn't go through them first.
I can say that in the lake area, it is very common for subdivisions to be platted that have restrictions set forth in the plat and not have a homeowners association set up, and then it is set up later. And that doesn't necessarily mean it has authority to set forth those kinds of requirements. I'm not saying in this instance I'd have to review what
this
those
is a
bylaws
question.
say.
Because I'm just trying to understand both sides.
And again, this is just the first step. We're trying to get a variance for it. Whatever requirements are required later, we would, of course, have to go through those requirements.
Thank you.
Well, I agree with Gloria on 4 and 5, and I also disagree with number 1. I've been to the property twice, and I've walked on the neighbor's driveway to look, see if there was a problem with looking around a garage if it was there, and I don't see that issue. And when the city says they may throw something off on that garage when they're plowing snow or doing sidewalk or road cleanup, I have to have them look at the people on the right. They have a 7-foot wall 2 feet from the road that is a bigger safety hazard to me if somebody drove off that wall and went into that driveway. I think that's an issue. Value improvement, I've been selling real estate for 24 years. A garage in any house is an improvement and increased value. And as far as aesthetics go, it's not like there's any 2 houses on that street that look alike. And 2 houses down, there's one that a realtor would almost call a tear down because it's not in good shape at all. And you've got a 5,000 square foot house 2 doors down or 3 doors down. You've got a brand new house on the point. And there is nothing that is even like that house on that street. So as far as aesthetics, the house is white, it's got a blue roof, very modern looking house, and aesthetically probably looks as good, if not better, than most of the others. So that's my comments on the
Thank you. I
items.
would agree with that, and I'd say that the homeowners have rehabbed that house from when they bought it to bring it up to a better standard, better aesthetic, and that is the plan to do with a garage if they're allowed to build it.
Yeah.
Can I also ask, are you all aware, or were you aware that there is a sewer pump and a line running where you want to build?
I was just made aware of that. It's my understanding that it's been under the concrete that's there for, well, I don't know how long.
Since the beginning of the 90s.
I don't know if there's been any work done on that in the time at all.
So I own my own, when it comes from the street to my house, that's my problem. So if there were a problem, that's their problem, they'd have to dig under their garage or what?
This one is in city inventory, it's on our GIS,
Okay.
so that pump,
How do you
That-
build
that-
around that then? On this side?
what?
You guys, you were saying that the sewer line runs over the existing easement, and it's right kind of where they want to build.
Yeah, it is. The requested structure would at minimum fall within our sewer easement. We have 5 feet on either side of the line. They're asking for 4.3 feet from the side property line, and this board doesn't have the authority to grant variance to build inside of an easement. We own the line from our main to the grinder station. The only thing that is basically under the caretake of the individual property owner is the line from their house to the grinder station.
Carrie, I
Yes.
apologize. Do you have something that you can provide to us showing where that easement is located? Because I was not aware of that.
Is the line going to be a problem or not?
So it's gonna be this.
It's the only problem is the
green line here, Derek.
is already in
In
the
the easement.
This thing, so that's,
Gotcha. I just saw it.
it, this is GIS, so it is under or on the edge of that existing concrete, and then we have 5 feet either direction. So there's no way, so the structure you're proposing is at least going to be into
But if
the easement.
structure was side of that line, would that change the analysis?
That's why I asked.
As to that part, yes.
Yeah, if you pulled it out of the easement, at least it at minimum changes that side.
And I understand that.
That's my.
Yeah.
I mean, you wouldn't approve a permit over that in the first place.
No, yeah, well, we wouldn't approve the building permit.
Now we can approve.
So it might be that we need to amend our request
They can't
of
build over
locate,
it.
based on the location of that.
He just said
My
they can't.
suggestion would be that you,
They're going to have to reach it.
at minimum, have whoever did your site plan locate that line and that easement so that you can see exactly what you're dealing with.
Okay, yeah, I wasn't aware of that easement there.
Typically, that type of stuff is on a site plan that is given to us. Sewer lines, valves, stations, that way we know what we're dealing with as well. And this just happened to be a situation to where I was talking to some of the public works guys and had them bring this up and found that we had the issue. So
But Kerry, there's no new concrete
that
any
doesn't
closer.
matter. They're building structure over the.
Right, but if you backed up the garage towards the house further, a foot,
Well,
I mean,
That's
there's
gonna-
no new concrete. He didn't pour new concrete. That existing driveway foundation is old concrete.
And well, we can't really tell from this whether it's over or just right next to it, but the issue is, had we known, we would not have permitted concrete over our line.
Driveway is not a building.
And
they did
now that we know about it, we're not gonna allow somebody to enlarge the
I
encroachment.
can't hear you. Please.
Sorry. We would not have permitted, it's hard to tell from this whether the line runs under the concrete or just right along the edge of it. It's close. But we would not, had we known where the line was, we would not have permitted that driveway to be constructed over it. Now that we are aware that it's there, we cannot permit, and the building department will not issue a building permit for any additional structure, any enlargement of the problem in the easement or over the line.
So if he backs up the garage a foot,
We would need a new site plan from them showing conformity with the sewer easement and the sewer line. Where the line is, where they intend to put the structure, and show that they can actually build it, that they're capable of obtaining a building permit.
my request then would be to allow time for the property owner to get a new site plan done, to amend the variance request so that the variance is outside of the easement envelope of the city, so it can move forward. Because I understand what they're saying, and their point would be, even if you approved it, you really can't approve it. So,
And you don't want to build a
right, and we don't
garage
want to build
where we have
across
to
it.
tear it down to get to our sewer line.
So,
Any type of structure, if you're building over any type of sewage lines, utilities, you either abandon it and start over building next to it, or we would tear it down. We don't want to tear it down.
Right. Okay.
So we would not want to build over it.
Okay.
The applicants requested for a continuance for time to do some additional study and potentially amend.
right.
And I guess there would need to be a motion to table for the time being by the board.
Are we gonna get the HOA, the bylaws and all that then?
Yeah,
Before the next
I
one?
would.
So we can get the,
Does the homeowners association have a copy of the rules and regulations?
Can we, before we continue, can we please hear from them?
Yeah.
And we would suggest waiting on that. I know you guys are all here to comment, but I think it would make more sense for you to comment on the final application rather than the.
That's,
I can't hear you, sir.
He wants to make
They
a
want to make a
statement.
statement.
Okay.
But I think it'd be more, yeah. This is moot at this point because they're going to. But there still needs to be some corrections to the record. Well, we're not done making the record, so, but I think if there's a motion to table, then we're done today and we'll come back and address it.
Make a motion to table it until we get a new site plan.
second.
All in favor?
Roll call.
Roll call, please.
Commissioner Katcott,
Agree.
Commissioner Green,
Agree.
Commissioner Bauman,
Agree.
Commissioner Gross,
Yes, agree.
Commissioner O'Keefe.
yes, agree.
Okay, so we will bring this back to the Board of Adjustment whenever they are able to provide us with a new site plan and further information.
Well, is there any further business?
Speak up. Can't hear.
Is there any further business to discuss?
I don't have anything, Mr. Chairman, unless you all do. Other than the dinner that we have on the 25th, and I hope you're all able to make it.
Yes?
Someone raised his hand.
It doesn't matter.
Yeah, we don't do public comment. I know they want to talk. I know you're here to talk, but we got to follow the procedure. You can, if you want to submit it to the planner, he'll put it in the file and it'll go in at the next meeting. So, yeah.
And then we'll have a full new hearing that will address any.
Yeah, we're not trying to silence you, but we're getting the cart before the horse, we don't want to, we're getting the cart before the horse, so,
Now that they've.
yeah. Because when they amend, they can also come back with other changes, and so what yeah, I get it, but the right way to do it is to actually know what you guys are here to talk about, and then we'll talk about what they actually are asking the board to take a vote on.
We need a motion.
I'll entertain a motion to adjourn.
Motion to adjourn.
Second.
All in favor?
Aye.
We're now adjourned.
He's okay.
Yeah, I don't need your paper. We're gonna have to bring it back.